Alright, so we've gone deep on wills. Now let's talk about the other path people take, sometimes intentionally, and sometimes by accident. This lesson is about what happens when you don't create a will. No instructions, no named executor, no written plan. In legal terms, that's called dying intestate. An intestate doesn't mean your stuff disappears, or the court just takes everything. It means the legal system handles your affairs. This could be a valid choice, but to make it effectively, you need to understand the outcomes. So it is important to know that even without a will, your estate still goes through a process. One partial exception to note here is when a married person dies leaving only a surviving spouse and children they share together. Many states may give the spouse most or all assets in this scenario. But if there are children from a prior relationship, the outcome can be very different. So assuming your spouse has already passed away, or there may be some inheritance questions, then the court needs to initiate a formal process to manage your estate. When there's no will, there's still a legal job to do. So step 1 is to appoint the person to manage the estate and take it through the probate process. Someone will need to collect assets that are in your name alone, pay valid debts and taxes, and then distribute what's left. That process is probate, or a probate-like court process, because the court needs a legal authority figure to sign, transfer, close, and distribute. When you have a will, you usually name an executor, also called a personal representative in some states. Without a will, there's no name choice. So someone has to petition the court to be the administrator and basically say, I want to be the person in charge. Usually, courts prefer close family, like a spouse or adult child, so long as they're willing and legally qualified. But here's where real life shows up. What if two people both want the job? What if nobody wants the job? What if the people who want the job shouldn't have the job? This can get messy fast. If multiple people petition to be appointed, the court decides who has priority under state law. And if no family member or close friend is willing, or able, or responsible enough to do it, the court can appoint someone else. And in some situations, this can mean a creditor can end up driving the process because they want to get paid. That doesn't mean the creditor inherits anything. It means they have motivation to make sure the estate gets opened and administered, so their debt can be collected properly. Another important reality, administrators are typically entitled to compensation and reimbursement for expenses. That compensation gets paid out of the estate before heirs receive what's left. So the longer and messier things become, the more the estate can get drained by administration costs, especially when there's conflict. Step 2 is to decide who inherits your estate. The state essentially writes a virtual will for you following the laws of intestate succession. Every state has a specific formula designed to be fair, but because it is a one-size-fits-all rule, it cannot account for your personal relationships or your specific values. Generally, the pattern is as follows, with obvious differences of course in some states. Spouse and children first, then parents, then siblings, then nieces and nephews, then more extended family, grandparents' lines, aunts, uncles, cousins, and so on. Many states use the per stir peas concept that basically means if someone who would have inherited is already deceased, their share often drops down to their descendants. So the family tree can keep going, and that leads to a surprising outcome. Intestacy can pull in people you never expected to benefit from your estate, which leads to step 3, when there are no known heirs. This is the situation when there are no known obvious heirs. Let's say you were the only child of an only child and never had children. Or relatives may appear unexpectedly, claiming they are your closest relative and should inherit your estate. What happens then? The court process doesn't shrug and stop. Typically, there's an effort to locate heirs. That can include using formal notices, genealogy research, and sometimes hiring investigators who find relatives you've never met. This is where the rich uncle fantasy shows up. But in real life, it's more like, congratulations, you're the closest living relative, as a second cousin once removed, to a person you've never heard of. And yes, that can mean your estate ends up going to people who had no relationship with you at all, because the legal system is following the family tree, not your personal story. And what happens if there are truly no heirs that can be found? If a person has no qualifying heirs under state law, the estate can S-sheet, meaning it transfers to the state, and for real estate, often to the local jurisdiction. That's not common, but it's real, and it's the final default when the family tree runs out. One other note, if an estate is small, often below a specific benchmark, many states have a quicker process, sometimes only requiring something called a small estate affidavit or other process that acts as a shortened probate. The requirements and application are dependent on your local state laws. To see intestacy at work, let's look at the story of a man named Gerald. Gerald's mother passed away without a will. Gerald had a brother, David, who had severe disabilities and relied on government assistance. Under normal circumstances, Gerald's mother would have likely placed David's share into a specialized trust to protect his benefits. However, because there was no will, the law required that the estate be divided equally and given directly to the two sons. When David received his check, it counted as an available resource, and he was immediately disqualified from the government programs he needed for his daily care. Used up quickly to cover medical costs that otherwise would have been covered by the state. This wasn't what their mother intended, but without a written plan, the court had no choice but to follow the standard formula. Even if the default distribution matches what you would have wanted, Intestate estates often take more time and money because the court and attorneys may need to do extra work, like proving who the rightful heirs are, resolving disputes about who should be in charge, and handling extra court requirements that a will often streamlines. And if you have minor children, the choice to have no will means you may be leaving much of that decision to a judge without clear written guidance from you. While courts try to make excellent decisions, they do so without your written input. This can lead to family friction if multiple relatives disagree on who should be the guardian, turning a difficult time into a much more complicated legal process. But let's be fair. There are situations where intestacy might land close to someone's wishes, such as a simple family structure, long-term marriage, all children shared by the same couple, no special distribution goals, no desire to treat anyone differently, and minimal risk of conflict. In those cases, the state's default plan might be good enough. But even then, the trade-off is you're accepting the court's choices on who runs the estate, how quickly it moves, and what hoops have to be jumped through. So the real question isn't, is intestacy always bad? It's, am I okay with the default settings? By watching this video, you have gained the clarity to see where the default path leads. You now understand that while the state's plan is designed to be orderly, it may not align with your specific family needs, such as protecting a loved one with disabilities or naming a specific guardian for your children. If you are ready for a small immediate step, I invite you to look up a simple, reliable overview of your state's intestacy rules, just to understand the default framework. Simply reading that one-page summary will show you how your state would divide your current assets. In the MyEstateKit app, we have provided resources to help answer some of your questions and explore the options available. You are making an informed decision about your future. Whether you choose to create your own roadmap or use the one provided by the state, you are doing so with your eyes open.